A very good evening, ladies and gentlemen. I welcome you all and here for this today's enlightening webinar on addressing cost escalation owing to Russia-Ukraine war and COVID-19 pandemic and other influential factors. So I am Pallavi S. Savan. I am your moderator for today's session, and we'll be talking about this cost escalation paths which the construction industry is facing on account of COVID-19, Russia-Ukraine war, and other geopolitical and socio-political factors. So, before getting into the topic, I would like to welcome our panelists and speakers today who are coming from the industry and each bringing unique perspectives and extensive knowledge about the events and today's topic. So basically, I just want to introduce all the panelists one by one. So starting with Mr. Shaurav Lahiri. So our first expert is Mr. Shaurav Lahiri, who is a specialist construction and international arbitration lawyer with over 20 years of experience. Shaurav specializes in energy and infrastructure disputes. He represents clients in sectors including oil and gas, petrochemicals, power, and building and other infrastructure sectors. The Shaurav has practiced law in multiple global locations, such as including Hong Kong, Singapore, London, Dubai, and Beijing. He has also appeared as counsel in courts, arbitration, mediation across Asia Pacific, Gulf states, and Europe. Besides England and Wales, he is qualified to practice in Hong Kong and holds full rights of audience in the courts of Singapore and Dubai International Financial Center. So I extend my warm welcome to Shaurav. So next we have on board is Mr. Ritin Rai, who began his career journey in 1998 at Jones Day before heading to practicing corporate law in India. So Ritin has been designated a senior advocate by Supreme Court of India in 2019. Ritin brings his corporate law experience to various commercial and regulatory disputes covering areas such as company, competition, insolvency, telecommunication law, etc. So Ritin, as an Indian law expert in courts on or forums outside India, has appeared in Indian courts as both counsel and arbitrator, including the Supreme Court, High Court of Delhi, as well as arbitral tribunals governed by both ICC and SISC rules. Ritin is also an honorary adjunct professor of law and distinguished professor of legal practice at Jindal Global Law School. So next we have is Mr. Rohit Singhal, who is a CEO of Masin, which is a renowned construction arbitration expert operating firm across 8 countries. So with over 25 years of international consulting experience, he specializes in construction dispute resolution, contract analysis, arbitration and litigation supports, and expert testimony. He has been listed and recognized as top 10 influential construction experts in Construction Week Middle East Power 100 list 2022, and has also been honored with the prestigious Outstanding Expert of the Year Award 2019. Rohit's expertise includes serving as a lead expert in numerous arbitrations appointed by both courts and arbitral panels for more than 50 international cases involving delay, technical, valuation, and quantum matters. So I welcome Rohit Singhal. Last but not the least, we have on the board is Ms. Kanika Arora, who is partner at MRP Advisory, who actively contributes to the firm's arbitration team, engaging in both domestic and international commercial arbitrations, mainly focusing on construction, energy, and infrastructure sectors. She holds experience in high courts, NCLTs, and legal due diligence. With the Indian law qualification, she holds LLB, LLM in oil and gas law from University of Reading, UK, and a doctorate in business administration law from Swiss School of Business Management. Kanika has been shortlisted for Dubai International Arbitration Center's 40 Young Practitioners Group, Forbes Top 100 Lawyers in India 2022, and Business World's Top 30 Under 30 Lawyers in 2022. And she is also an associate of CIARB UK. So this was regarding our panelists and speakers for today's session. So I extend a warm welcome to all the speakers and also the audience for this today's webinar. So now let us begin with the most awaited session. So just to set the pretext, today's webinar aims at the unprecedented rise in prices owing to two significant, rather huge events, which are COVID-19 pandemic and Russia-Ukraine war that the world has witnessed. Basically, these two events are the events which none of the construction contractors could ever envisage at the time of bidding or at the time of setting the contractual timelines and getting into the commercial and contractual arrangements with the employers. So as we all know that starting around December 2019 and getting more intense in India from March 2020, COVID-19 really hit everything back. India went through a nationwide lockdown from March 2020 and it got extended by 180 days. Then in 2021, the second wave hit the nation and third wave coming early 2022. So before contractor could come out of this wave of COVID waves, the another tragedy happened that the world witnessed one of the biggest wars between Russia and Ukraine, which disrupted the entire supply chain and inflated the prices of steel and other metals like never before. So owing to these two big and major events, the industry has seen the steel and metal prices surge globally due to the rising raw material cost and the other demands in the supply industry and the major economies like India, China, Europe, and Middle East, and etc. So if you just see this particular graph actually I've portrayed here, which actually shows the trend of all commodities versus the actual prices of steel, which there are three steel materials that I've taken: HRC, CRC, and rebar. So you can actually see the inflation or the fluctuation in the prices of all these steel materials as against the all commodity prices. So basically, actually, in my view, I can very well say that the COVID-19 pandemic and this geopolitical conflict between Russia and Ukraine war, it has artificially rather inflated the commodity prices and the other steel prices, impacting the supply industry and the raw material cost, and disrupted the entire procurement cycle of the contractors, which was actually beyond the control of the contractor, employer, or rather the Indian government as well. This is what I feel. So if you see here in this particular graph, that at the start of the COVID-19 lockdown phase, everything was pretty steady and in line with the commodity prices. This particular line is for the all commodity indices. So this till this point, this is pretty much in line. In fact, the COVID wave, the first wave had started somewhere in March 2020. However, till June, July 2020, it was still fine. The moment the lockdowns were easing out and the industry was opening up again, we can see the actual prices of steel, they started rising. So this is the supply and demand imbalance post COVID wave 1, which we can see here in this graph. Then when the India was entering into the second wave, the inflation further went up. And here, this is the point. This is the month of March 2022, if you can see here in this graph, that this actually reached the peak of the inflation. If I talk about the figures, in this particular time, the commodity price was approximately 120%, whereas if you see this particular peak, the actual steel prices were close to 200%. So it's almost double the prices, and this much inflation that the India and the world in the construction industry had seen with respect to the steel prices, and the other metals also were carrying the same trend. So this particular problem that the entire industry is facing, which is actually the today's topic of discussion between the panelists and the audience. Actually, in my view, there's another factor which could be a reason which is igniting the dispute between the parties, the contractor and the employer, and that is the price adjustment formula, which is currently there in the construction contracts. Basically, the price adjustment formula which is there in the contracts right now, it actually relies upon this wholesale price commodity index, the WPI index. And somehow, because of the actual trend going very, very far from the indices which are being published by the governmental bodies, the formula which is there in the contract, is not able to cater the actual inflation or the unprecedented or unforeseeable rise. Maybe the formula must not have envisaged this much rise to this extent. This whooping rise was not witnessed or was not foreseen by the formula, maybe. But this is, in my view, one of the reasons that why there are disputes between the parties when it comes to the price inflation and then mitigation on account of this cost claims. So moving forward to our discussion, let us hear it from the panelists that what are their views on the inflation on account of COVID-19 and Russia-Ukraine war. So before diving deep into the topic, let us start with the fundamental question. So I would like to know from Mr. Ritin that what is your view and what is the stance of Indian courts regarding COVID-19, and has it been officially recognized as force majeure event? So over to you, Mr. Ritin.
Thanks, Pallavi. Thank you for sort of highlighting the major points that we're going to try and discuss over the next hour. Obviously, this is an extremely topical and important issue. Very early on in the COVID time, there were a few cases that came before our courts for urgent interim relief by parties, seeking, for example, to prevent the encashment of bank guarantees. Halliburton was the first case that actually came to the Delhi High Court. And so we've had some decisions by the courts on what force majeure means, what COVID means, how it impacts contractual performance right from that time. But obviously now we're going to see more and more cases getting decided on merits when claims are made and adjudicated by arbitral tribunals. Just to lay the groundwork for whether COVID has been recognized as a force majeure event, really what is always at play in these kind of issues is two competing contract law principles, right? So the first principle is sanctity of contract, where courts or any adjudicator holds parties to their contractual bargain. And then there's this other principle where, uncertain events can, in some cases, discharge a party from contractual performance. So really, it's this balance that courts are always trying to strike when looking at these issues. To answer your question directly, did India recognize COVID as a force majeure event? I think that it certainly did. And that it did very, very early on. I mean, as early as February 2020, you had the Ministry of Finance of Government of India circular saying, that a force majeure event is an extraordinary event or circumstance beyond human control. An FM clause in the contract frees both parties from contractual liability. And then it went on to say, a doubt has arisen if the disruption of supply chains due to the spread of coronavirus in China or any other country will be covered in the force majeure clause. In this regard, it is clarified that it should be considered as a case of natural calamity, and force majeure clause may be invoked wherever considered appropriate, following the due procedure as above. So the fact that COVID is a force majeure event, I think, is less in doubt. But the real issue for us, and I think for this entire audience, is what are the consequences of that force majeure event for parties to a contract? So, for example, I mean, we've talked about this a lot in disputes that we've been in, but the beginning of COVID was a big boost to dining, to companies that were providing food services or catering services, right? So they cannot obviously claim COVID as a force majeure event that discharges them from performance. And the point, therefore, is that a force majeure event is one part of the analysis. The second part of the analysis is how does it impact a party to a contract? And again, just to lay the groundwork for some of our discussion, there will be two kinds of cases that come before a court. The first is when the contract itself has a force majeure clause. And in those situations, the way the Indian courts look at it is they look at that as a contingent contract, a contract that upon the occurrence of some contingency discharges a party from performance or suspends that party's performance or gives that party some other kind of relief. So when there's a force majeure clause, really what we're looking at is the court interpreting that contract, interpreting in the first instance whether that force majeure event is made out, and then interpreting what that event means for contractual performance. So that's when the contract itself has a force majeure clause. And then, of course, there's Section 56 of our Contract Act, which provides for frustration, where a contract becomes void because it becomes impossible to perform. And there, I think the English law initially or even now is that a contract is frustrated because they read in an implied term that parties would have always intended in these circumstances that the contract should be put to an end. Indian law doesn't read it as an implied term. When the Indian courts look at this issue, they say that if there's an implied term, then it's a contingent contract and Section 32 operates. But otherwise, if there is a position so fundamental that the whole purpose of the contract or the basis of the contract has been frustrated, then the Indian courts go to Section 56 and allow a party to treat that contract as being void. I think for construction contracts, obviously, that latter situation is not really what we're looking at. This is the contractor or an employer who want to continue the contract, and the issue is apportionment of cost or risk arising from extraordinary events like COVID or the Russia-Ukraine war. I mean, both of which have gone on for several months, close to years actually. So again, just to reply to your question, I think yes, Indian law and Indian courts recognize COVID, but then to speak like a lawyer, it all depends on the facts of a case as to what that determination will mean for a party making a claim or seeking some kind of relief. That's how I would start to answer it and set up the discussion.
Yeah, thank you so much, Ritin. That was very insightful, actually. So, having said that, the Indian courts are recognizing COVID-19 as the force majeure event. So, and you have also mentioned about the extension of time circular. So, I would like to ask Mr. Rohit that can you please explain the finance ministry circular on this COVID-19 related time extensions for the construction contracts, and how does it affecting the granting extension of time from the employer to the contractor, and basically the provisions which are there in this particular circular. So over to you,
Rohit. Thank you, Pallavi, and thank you and good evening, everyone. So as Ritin explained, immediately after the COVID-19 pandemic started or epidemic started, we had finance ministry issuing a circular taking into consideration the lockdown situations which had emanated owing to COVID-19. And the finance ministry circular stated a couple of very important points for the construction industry. Number one, it stated that, look, it is recognized that COVID-19 and the associated lockdown are beyond human control and should be termed as natural calamity. It stated that it should be considered as force majeure event, and force majeure clause under the manual of procurement of goods can be invoked. And then it said that contractors and supplier in violation to their contractual obligation, the contractor shall be under no obligation to take action as per the guidelines or as per the contract provision, i.e. typical force majeure, where the penalties and the liquidated damages are kind of relaxed, which are otherwise the right of the employer. And then one very important thing which it said was that the circulars which was issued by the finance ministry on 13th of May 2020 recognized that in view of the restrictions placed on the movement of goods, services, manpower because of the lockdown and other prevailing situations, various states and the country, the contractual obligations of the contractor and the PPP concessionaires might not be fulfilled by their respective parties, i.e. the contractor and the PPP concessionaires. And also, the PPP concessionaires who were probably operating road and other BOT, PPP projects might not be able to earn the kind of revenue which they would have earned but for the lockdown situations. And therefore, the government said that the period of the contracts, construction contract and PPP contracts need to be extended to the tune of approximately 3 months all the way to a maximum of 6 months of time, and in certain instances, even up to 8 to 9 months of time. And but one thing is very important. It did say that the period of extension may be decided based on the specific circumstances of the case and the period for which performance has been affected by the force majeure event. Now, this is a very important aspect. Today itself, in the first half, I was in a meeting wherein a very big national importance project discussions were going on a claim related to extension of time. And the employer and the engineer in this case had granted only 38 days extension of time to the contractor. and the contractor said that, look, this is wrong. In my other package, with the same employer, you have granted me almost 7 months of extension of time because of the presence of this finance ministry circular. Why are you giving me only 38 days in this case? And the answer with the engineer said was twofold. Number one, it said that, look, the lockdown and the force majeure of COVID-19 in actual affected you only to the extent of 38 days. Now, just saying that, look, there is a blanket finance ministry circular which grants me 6 months of extension of time cannot be used. There has to be a causal link between the force majeure event, i.e., COVID-19, and the extension of time which is being claimed. And that's very important. Number two, which the finance ministry circular also put forward as a disclaimer to this extension of 6 months of time because of COVID was that that supposedly there is a scenario where the contractor is at default for its contractual obligation prior to the start of the COVID, which is 19th February 2020. Then whether the invocation of force majeure clause pertaining to COVID-19 can absolve the contractor of all its non-performances is probably not the right scenario. Example that the contractor is already not working, it has suspended the work, or it has demobilized its resources, and then COVID-19 comes. The contractor is already in default to its obligations under the contract because of suspension, maybe for reasons which are beyond the control of the employer, not attributable to the employer. So in such a case, the contractor is already at default. Now there it cannot go and seek that, look, COVID-19 finance ministry circular or the other circulars are there, therefore you need to give me an extension of time. So these are two important disclaimers which I would definitely like to add. These are issues which are debated many a times, but definitely the finance ministry has come forward declaring COVID-19 as a force majeure. So therefore, extension of time due to COVID-19 is still easy. Of course, we'll discuss as we move forward in this webinar about the prolongation cost and the extra cost which the contractor might face owing to COVID-19. Thank you.
Yeah, thank you so much, Rohit. Actually, you have put across very two important aspects of this finance ministry, which is definitely going to help everyone. So the as you rightly said, the other part of this particular pandemic is the cost part. So in continuation with what you have just answered, I would like to know from Ms. Kanika that what is the current stance of Indian courts when it comes to addressing claims for extra cost incurred due to COVID-19 pandemic? And are there any notable cases or precedents that you can put light on?
Thanks, Pallavi. I think I'm just going to continue where Ritin left because we have only so many precedents to this concept till today. The topic of price escalation because of COVID-19 being one of the major force majeure events that construction companies have faced in the last couple of months is definitely a trending topic for EPC companies right now. EPC companies as well as government PSUs in India. I feel like everyone's finding the right answer. But frankly, because a lot of arbitrations are still ongoing on this topic, we don't actually have a lot of judgments being passed. We're yet to see a full and final answer to, what is right and what is not, or what is acceptable by courts. When we talk about price escalation as a concept, the courts have given their views, although they have deferred time to time. We've had cases like Tara Kore Company and Kochi Shipyard, where the concept of price escalation was considered taking into consideration a contract that didn't have a price escalation clause. And in that, the court said that if the price escalation is marginal, then it shouldn't be granted. But if it has a crushing effect on the performance of the contract, then law must come to relief. But now that we are actually in that situation, how much is law actually coming to relief? We'll only find out in the next couple of months or year or so. Contradictory to this stand, we have a case of CMEC and Oil India, where the price of high-speed diesel had risen significantly because of a regulation which was pronounced by the ministry. And it was argued by the contractor that we are rightfully in a position to get a price escalation because this was something which was not foreseeable. Although the arbitrator took this into consideration, granted the price escalation, the award was finally set aside by Guwahati High Court and also by Supreme Court, saying that this is a fixed price contract you cannot be claiming a price escalation in this case. If you're fixing prices of a contract, then you should have taken into consideration that this can have certain fluctuations in the future. Coming back to what Ritin has said, it's definitely a position where the courts in India have accepted COVID-19 as a force majeure event, but it doesn't actually end at that. The story only begins from there, which is actually elaborated in the Energy Watchdog judgment, where Justice Nariman has gone to elaborately explain the ambit of what a force majeure event actually entails and how is it going to act as a relief for parties, where he says that just the existence of a force majeure event is not something that completely absolves a contractor of its contractual responsibilities. It doesn't mean that you can just get relieved from performing the contract at all. It actually means that, as Ritin said, that you have to look at the situation holistically, the terms of the contract, the factual matrix of performance of the contract, as well as have you tried to mitigate the consequences or the circumstances which are arising. Say, for example, it's often the case that government PSUs argue this in India that the contractor had to acquire an amount of steel at a certain price from this particular vendor from this particular country. It had some escalations in price and in cost, and therefore the contractor claims an extra cost because of it. And the first question that the government PSU will ask you is, could you have obtained this amount of steel at a similar price from an alternate vendor, if not this vendor? So these are questions that keep coming up. Yes, there are situations when it becomes impossible to perform the contract. And the Indian courts have taken that into consideration under Section 56 of the Indian Contracts Act. We've got cases like Satyabrata and Alopi Prasad, where the courts have accepted situations where the situation compared to when you signed the contract to when you actually perform the contract are so significantly different that it becomes more or less impossible to perform the contract, and that leads to the contract being frustrated. But as far as specifically COVID-19 is concerned, the law is still shaping up. We're not there yet, but the Indian courts are being acceptable of the situations that are persisting at the moment. But the courts are also being mindful that a line has to be drawn somewhere. You can't kind of go on endlessly arguing the same point to no end.
Yeah, thank you so much, Kanika. This was very great insight actually on this Indian contract, with perspective of the Indian law. So actually, having heard from you and Ritin and Rohit sir also regarding this uh, stance of Indian scenario on COVID-19, I would like to also understand from Shaurav that what is the prevailing position of English courts with respect to the claims of additional cost arising from inflation caused by COVID-19. What are Indian courts saying on this?
Good evening, everyone. You would have thought that now that we're in the third year of post-COVID or COVID situations, that you'd have a plethora of judgments coming out from the English courts on this issue. And there are, but none of them relate to construction. There are a lot of COVID judgments from the English courts, but as to what it means for the purposes of construction contracts, there is nothing that I'm aware of that is of any significance. What does that really entail? That does not mean that there is no entitlement to relief from COVID-19. Of course, you have the circle in India that Rohit and Ritin spoke about. Under English law, as you know, force majeure is not a concept that exists as part of common law. It is a creature of contract. There are other concepts such as frustration, which you've already spoken about, which may come into play, but force majeure as such needs to be spelled out in a contract, and the consequences of force majeure need to be spelled out in a contract. I think it's generally accepted that the pandemic would be a force majeure event. The causal impact of that on a party would be a matter for the usual principles of causation. But the problem that we have been grappling with over the past 2 or 3 years is, okay, I think getting time or an extension of time for force majeure is not a problem. The pandemic is not a problem. Most employers are also willing to give that, but nobody wants to give money. So how do you get money? Because force majeure in most contracts is one of those events for which there is time, but no money entitlement. So we've seen, I've seen various arguments being put forward in relation to this using existing contractual law principles. So four come to mind. What you can, where a party can utilize the cost impact of COVID in order to get relief. Firstly, using the principles of a variation. If you look at FIDIC contracts, variations include changes not just to the scope of work, which probably will not have changed in the COVID situation, but also to the timing and the sequence of work. And that potentially could have had an impact, could be changed. And a variation would include monetary compensation for such a change. And we have seen in many countries that the government has instructed employers to reduce the number of people on site, reduce transport to site. I mean, these are all directions that employers have passed down to contractors. Now, whether these amount to variations or not, they may well do. And if they do, the consequences of that, the commercial consequences of that in terms of money, may be an avenue. The second and the third aspects are sort of mirror images of each other. There are concepts of constructive acceleration, for instance. So if, for instance, an employer is not willing to grant time or sufficient time for a reason of COVID, and the contractor then says, I have to then complete by the original time period or by a very small extension, I have had to increase my resources post-COVID to meet that. And there is a cost associated with that increase of resources. So it's a slightly different cost. It's not the cost as a result of COVID during COVID, but it's a cost as a result of COVID post-COVID. So that's one aspect. And the third aspect is related to this. There is generally a duty to mitigate. So if COVID has caused a party to be in delay and he expends money to mitigate that delay, to recover that delay, then potentially that is a cost that can be recovered. Again, these are post-COVID impacts, but not during COVID. And finally, on this point, to wrap up, there is often a change in law provision in contracts, which does have a cost component associated with it. So a lot of arguments that I've seen veer away from characterizing COVID-19 as a force majeure event and characterizing it rather as a change in law because of the regulations countries have passed to deal with COVID. So that is another potential angle in which to bring claims for cost and damage.
Yeah, thank you so much, Saurav. This was actually a very great insight about the English course, because having being from India, so it's very important for us to know also what the English courts are taking stance on this COVID-19 cases. So moving on forward, I would like to know from Mr. Ritin is, under Indian law, if a construction contract does not contain a specific law under which the increase in metal prices can be claimed on account of COVID-19, can the contractor still claim cost compensation for such cost escalation? And what are the legal principles and arguments that the contractor could potentially rely upon? So over to you, Ritin.
I think, I think Saurav has so well articulated four contract-based arguments that perhaps a contractor can make for enhancement of costs. I don't think I have too much to add to it, because the context, of course, is, as Saurav was also saying, that typically a force majeure clause will only excuse or suspend performance. In that sense, it will give some relief for the time for performance, but it may not actually give relief for the cost of enhanced of performance or timely performance. And so I think if your contract doesn't have a specific clause addressing or giving relief for an increase in prices, and equally your force majeure clause also doesn't have that as one of its consequences, then it's a difficult position for a contractor, other than the kind of arguments that Saurav was making, that if you can fit it into a variation claim, or if you can fit it within change of law, or if there's, accelerated performance that you have to do to deliver the construction on time. Because the other aspect is, many contracts actually do contain a provision for cost enhancement linked to like a wholesale price index.
Right.
And so that then becomes an argument for the other side to say that to the extent cost enhancements were being considered by the parties, they are contained in their universality in that clause. So if you can house your claim within that clause, then you have a claim. You can't have a claim outside that specific provision. And that applies both to, sometimes contracts will talk of particular equipments for which there can be an increase in cost. And the argument then is that all other equipments, there cannot be enhancement of cost. Of course, we're at this point, I assume, not dealing with a fixed price contract where the arguments become even more hard to make. So I would leave it at that. I think if there is no clause, then I think Shaurav articulated the manners in which you can use other contractual provisions to try and make a case for enhanced cost claims.
Yeah, thank you so much, Ritin. Actually, regarding the other contract clauses and the other provisions in the contract, so we do have the discussion scheduled on that as well. But before going to that, I would again go back to Shaurav to understand about the specific timelines that are required to be adhered to by the contractors. So my question to you is, how does the construction contract address the specific timelines and notification requirements for the contractor to inform the employer about any cost and time implication resulting from COVID-19 pandemic? And definitely, what are the consequences that the contractor could face if these notifications or if these requirements are not adhered to? So over to you, Shaurav.
Yeah, so English law historically has been quite strict in terms of compliance with notification provisions, not just for COVID or other force majeure events, but generally for any things causing delay or increase in cost. Now, strangely, we have seen over the last couple of years a somewhat relaxation of the position, of the strict nature of the position in England. There's a case of Brascon in Gibraltar, where the court said, okay, in the context of delay, and COVID could cause delay, it's open to the contractor to notify, of course, within a certain number of days of the event arising or when he became aware of the event. But it's also okay for him to do so when he became aware that critical delay is being caused. So that actually postpones the date of compliance with notification provisions, because non-compliance with these provisions is quite harsh. I mean, the contracts are fairly clear that your entitlement would be lost completely and you won't have a right. So there is, Ritin's point earlier about sanctity of contract, to give credence to or to give force to contractual provisions. The courts have to take that into account. So the court, Justice Aikenhead in that case, was trying to move the starting line somewhat. And what we've seen in Hong Kong and in Dubai recently in the DIFC courts is a complete reversal of this. And these courts are holding notification provisions very strictly, constrained very strictly. In Hong Kong, there was a Court of Appeal case in Maida, which was a little bit unfortunate for the contractor. The contractor thought the claim should be made for unforeseen ground conditions under a variation. So it applied for a variation, but it was later found out that the proper clause was a different clause for which it had to give notification. And it hadn't given notification. So, those arguments that we usually make and receive that, ultimately the employer did know what it was about, was rejected by the court and said, no, you had to comply with the strict notification provisions of an unforeseen ground conditions. To be fair to the employer, he did not know that that's really what you were claiming. And in Panther, which is a DIFC case, and maybe, I don't know whether you guys were involved in that case, but there the court said, no, you comply with the FIRIC cause clause strictly. It is 28 days from the day you were aware of the event, or you should have been aware of the event. There is no later time scale. So there is a departure internationally from the latest English position, and the latest English position is a departure from previous English position. So it's all to play for, really.
Yeah, thank you. Thank you so much, Shaurav, for that. So moving on to the cost claim, which is to be prepared by the contractor, or which are being prepared by the contractor on account of this price inflation. So in this regard, I would like to know from Mr. Rohit that what are the specific documentation requirements for submitting this price variation claims in the construction contracts to address the whooping price escalation on account of these two events? So what are your views on this?
Thank you, Pallavi. So basically, you see, there can be two possibilities. One is that the contract contains a price escalation formula. Now, as you can see in this graph, the general price escalation formula in Indian contracts are based on the indices like the wholesale price index or the CPI index and all that. But as you are showing in this graph, these COVID-19 and Ukraine war are not the formulas are not able to capture the huge amount uh, of increase in the prices of the commodities, especially the metals and steel, from what is specified by the escalation formula using these indices. Now, generally, the law and the arbitration tribunal would expect that what is the actual loss which the contractor who is trying to claim a price increase has suffered, which means that if there is a claim for increase in price rise because of COVID-19, and let's say the claim is related to increase in the steel prices, then the arbitration tribunal and the courts are generally intending to see that what is the actual loss, which means that the contractor will have to provide the amount of steel which has been delivered or has been ordered, or the delivery and payments have been done, and there is a amount of the value of the steel is far more than what is being compensated by the escalation formula. So what you do is you calculate what is the actual amount of money spent on procurement of the steel, which has been affected because of COVID-19 and the Russia-Ukraine war. And then you calculate how much is the compensation given by the formula, if formula is available. If formula is not available, then you just see that what was the amount at which the steel was being procured prior to the start of these events, and then the differential between the two is going to be the value of the claim. Now, this is what is expected by the tribunals and courts. But I have also seen that the many of the owners and employers do not want to get into this extensive amount of documentation, because this will require purchase orders, the material takeoff of the steel and metals, etc. The employers are trying to say, okay, let's replace in the escalation formula, instead of WPC, any other price index which could probably compensate the contractor. Like, for example, for steel, there is a JPC price index which is coming by the Ministry of Steel. So that index can be used by the employer or the engineer to compensate. But that's generally what the employer and the engineers are trying to find a way out to compensation, rather than getting into those extensive documentation of finding out what is the extent and magnitude of steel affected, what is the actual cost and all. So that also I have seen in my recent experience, wherein such kind of claims have been put forward by the contractor.
Thank you, Mr. Rohit, on this. So moving on to the next topic of today's session is the next clause, which is a typical war risk clause from general conditions of the contract that we have picked up. So basically, the clause says that the war risks shall mean any of the following events. So if you see the first point, it says the war, hostilities, and warlike operations, whether a state of war is declared or not, invasion and act of foreign enemy and civil war. So basically, the point here, which is to be noted, is the definition says that the such event occurring or existing in or the near country where the site is located. And if any war or such incident which the world is dealing with right now, Russia-Ukraine war, if it comes under this particular clause, then the another part of the clause says that the employer will be liable to pay the contractor for any increased cost or incidental to the execution of the contract, which are in any way which are attributable or consequent on or resulting from such incident of Russia-Ukraine war or such other associated incidents. So basically, by keeping this particular clause in mind, I would like to ask a few questions to the panelists. So starting with Mr. Rohit, I would like to ask you that, considering this ongoing Ukraine war, do you believe that this geopolitical conflict could potentially lead to an increase in prices for construction material and services? And if so, what factors would contribute to this price increase? And how might it impact the construction project both regionally as well as globally? So what are your views on this?
So basically, you see, both COVID-19 and Russia-Ukraine war have resulted in an increase in the metal prices. Your previous graph was very clear that when first and second wave of COVID-19 was there, there was an increase in the price as compared to the normal wholesale price index, which was at the bottom of the graph. And then there have been circulars by the steel ministry very clearly saying that the steel prices have gone up. There is an impact on the supply chain because of the Russia-Ukraine war. There are notifications issued by the other steel manufacturers like Jindal and Steel Authority of India, where they are very clearly highlighting that COVID-19 and Russia-Ukraine war are the reasons for the disruption and the increase in the prices of the steel. So there is very clear causal link between the two events, which is COVID-19 and Russia-Ukraine war, with the increase in the prices of the metals, including steel and all. So that's the first part of the question. Your second part of the question, can you repeat, Pallavi?
Yes, yes. So if this is the situation, then what factors would contribute to this price increase, and how this might impact the construction projects globally as well as regionally?
Yeah. So basically, supposedly there is an increase in the steel price. Now, this increase in the steel price definitely will impact the cash flow of the contractor, and he will have to shell out more amount of money to procure these metals and all. There was also a situation where probably because of the supply chain disruption, because of Russia-Ukraine war, again, there is a disruption in the purchasing ability of the contractor to purchase these metals and all. There have been instances where supposedly if a equipment order has been placed on a country in Europe and all, and this country in Europe was dependent upon gas coming from Russia or Ukraine, then there was disruption in the gas and hydrocarbon supply to the European manufacturer, as a result of which the European manufacturer has been delayed in its commitment to deliver the specific equipment. So I've seen one of the cases in an oil and gas dispute where a massive compressor delivery was delayed because of Russia-Ukraine war. So there is, coupled issues which are impacting. The Russia-Ukraine war has affected the prices of the metals. It has affected at times the ability of the contractor to perform its obligations and has caused delay and disruption to the contract. So that's the second part. And the third part of issue is that how this is affecting globally and nationally. As I said, I have come across number of arbitrations which have started between Russia and European and other contractors because of the restrictions and which have been placed on Russian entities and all. There are massive number of international disputes, including investment treaty disputes, which have come in because of the Russia-Ukraine war. Besides that, a lot of other disputes have started, not only between Russia, Ukraine, and European countries and Indian companies and Indian origin companies, working in outside India. There are indirect effects. For example, as I said, an Indian company is buying a European equipment. The European equipment is affected by the Russia-Ukraine war. So there is a dispute between the Indian company with the European supplier, which has, there is no direct impact, but there is a indirect impact of the war on the project which is being executed over here in India. So those are the issues. So it's not only the steel prices, the metal prices, which have been affected by Russia-Ukraine war. There are several other indirect impacts also which have taken place.
Yeah, thank you so much, Rohit, for this. So taking this particular thread forward, what Rohit had just said, so I would like to know from Mr. Shaurav that considering this particular clause, could the conflict in Ukraine, despite the geographical distance from India, can still be considered as falling under this clause due to its occurrence or existence in the country near the site? So if you can elaborate something on this.
Yes, actually, I'm a little surprised to see the phrasing of this clause, because the standard form clauses that I'm used to will not cover anything outside the country where the site is located. So this seems to be a little more generous than what you would probably get under FIDIC 17 as an employer's risk. I don't see any reason why the actual distance from between India and Ukraine should affect the applicability of this clause, because what is near, how long is a piece of string? So I think one has to take a purposive interpretation to this clause. And again, as everybody's talked about, Kanika talked about it, Rohit talked about it, we have to look at the causal link between the war and the impact on the contractor. So as long as a causal link is shown, the actual geographical distance, I don't think really matters. And I would think tribunals will interpret near quite broadly if a contractor can show that because of the war, his performance has been affected, whether in terms of time or cost.
All right. Thank you so much, Shaurav, for this. So, taking it forward, I would like to know from Mr. Ritin that what is your opinion about this Russia-Ukraine war being regarded as an unforeseeable event? So, according to the Indian law, what a contractor will the contractor be eligible to seek relief for the price increases in the metal attributable to the Russia-Ukraine war? So, what are your views?
Yeah. Well, I mean, specifically speaking about the Russia-Ukraine war, I think many people would have not foreseen a war in Europe extending for this kind of period, right? So that's not from a legal perspective, but I don't think anyone thought in this century or 2022, 23, we'd see this kind of a war for such a long period of time in the heart of Europe. But again, looking at it from contract and what contracting parties do, a war or an event that could be very disruptive is a foreseeable event, is something that they can bargain for and provide for in their contract. So I don't think anyone will be able to say that we couldn't have foreseen a war in Europe, because you could have foreseen a disruptive event. And then it comes back to whether this kind of a clause will inure to the benefit of a contract that is going to be performed in India. I think I partly agree with Shaurav that tribunals will try and read a clause like this more generously, but they will still be handicapped a little bit by the express language, right, which says occurring or existing in or near the country. So whether they will be able to say purposively this is what it was intended to do, whether they'll be able to say that, look, the effect of the event is actually spread out over a much larger geography, I think will require some persuasion and some evidence also being led about the impact that this event had on the performance of the contract in India. And that interpretation certainly finds support in the latter clause of this clause itself, right? Because that is even more generously worded, to borrow Shaurav's language, because it says notwithstanding anything contained in the contract. So it's a non-obstante clause. It overrides everything. And then if you see, there are two more phrases at the end of the second line that are in any way attributable to, consequent, resulting from, or in any way connected with any war risk. So again, very, very wide in terms of saying that if there is any kind of causal connection that you're able to show, then you will be able to get the benefit of this for your increased costs or incidentals, provided you make that notification to the employer, promptly. So again, I just echo what Shaurav said. It is a very generous clause, but even then, there will be some work to move the fact that the event may not have been occurring or existing in or near the country. It's referring to the event here, not so much the consequence of the event, at least in terms of the definition of war risk. But yeah, it's something that the parties can foresee a war, and therefore I don't think parties will be able to say it was unforeseen. Thanks.
Yeah. Thank you so much, Ritin, for this. So, in continuation to the same, I would like to know from Ms. Kanika that could you please provide some insights into the previous case laws which are related to this, or some other legal precedents related to the construction projects and instances where the price escalation resulting from the events like Gulf War or the similar events. So, if you can show some light on that.
Sure. I think when we talk about something like a war event, we're talking about price escalation because of various factors. It's not just commodity prices increasing. That's a given. But when we talk about supply chain being disrupted, migration of workers, laborers, shortage of the same, or extra hours put in by laborers, it all leads to a price escalation situation for any EPC company. The way I look at it, I don't necessarily think that the impact of a war event is physical in nature. It has to be geographical in nature. From an EPC perspective, it's more about the financial impact on the project at the end of the day. If because of an unforeseeable event or because of an event that I did not factor in at the time when I was signing the contract, a year into it probably, an event has taken place because of which I am unable to procure steel at the prices that I had factored into the contract. And that has gone beyond my control, beyond the employer's control, then I must be given I should be given the extra cost that I'm incurring. I'm not. It's an actual cost that the contract is incurring, and I don't think that is unreasonable to argue as long as I have enough evidence to support it. It becomes problematic for companies who do not maintain records or who do not have their paperwork in order when they're fighting such a claim. But for companies that actually have their paper trail in line, then I don't think this is something that cannot be argued. There is, when I was actually working on this point for another assignment altogether, there was a very interesting case that I came across by Madras High Court. It's a very old judgment from the 60s, where it's a judgment by the name of Eason Engineering. And in that judgment, there was a contract that took place for the supply of ghee in India. And the contract got signed, and during the performance of the contract, the World War II broke out. And or there were some events of World War II taking place at that point of time. And the prices increased drastically and astronomically that nobody could have foreseen that happen. I mean, it's a contract for ghee after all. And obviously, the supplier claimed extra cost because he said, I cannot be supplying ghee at the cost that I have promised. And this is going to be a bit more expensive to supply than what I had speculated. The Madras High Court actually granted that price escalation, saying that the warlike event that has taken place was something that was not factored in and has disturbed the entire foundational premise of this contract. And the contractor should be allowed to claim an extra cost that he's incurring to go on with the contract. Now, over here, yes, it would be a problem if the contractor abandons the project. That is something that the Energy Watchdog judgment has actually looked into. But for claiming an actual cost that the contractor is incurring, I think that if you have your paperwork in order, this is not something very, it's not something very difficult to argue before a tribunal.
All right. Thank you so much, Kanika, for this great example and the case law on account of this. So moving on to the next topic, this particular slide talks about the typical force majeure clause. So this is one the part of the clause 37.6, which states that if the force majeure event, if it is being continued for 60 days or for more than 120 days in a continuous in an aggregate period of 120 days and continuous period of 60 days basically. So if this happens, the parties can meet in to attempt the mutual satisfactory solution, or basically parties can think of renegotiation of the terms of the contract to continue with the work. So whether the next topic on in this particular webinar is the applicability of this particular clause, that how this is being referred to or how this is being interpreted or used in the Indian as well as in the global scenario. So I would like to know from Mr. Shaurav that how do you interpret this particular clause, and is it applicable for claiming additional cost due to the metal prices increase?
So this is also something that I don't usually see. It's probably an Indian contract from which this comes. So under English law, the first thing I notice is parties will attempt to develop a mutually satisfactory solution. Sounds like an agreement to agree, which to what extent that will be enforceable, I'm not particularly sure. Of course, you have similar things in a tiered dispute resolution clause where parties have to go through certain steps. And as long as you go through that step, compliance is sort of considered. In this sort of situation, usually for a prolonged suspension due to force majeure, contracts will spell out relief, the relief being notice given and then termination in all obligations seized of the parties. A renegotiation, which is how you termed it, is a possibility. It's probably a good outcome or a good possibility. And I guess if it is stated in the contract, there is more reason for a contractor or a employer to enter into these negotiations, which might avoid a dispute altogether. Renegotiation clauses are common in long-term contracts like gas pricing contracts, etc. But in normal construction contracts, this sort of provision is a little unusual to me. Can it be used to argue that this must mean I should get compensation for an increase in cost? Yes and no, because all it says is that you will attempt to develop a mutually satisfactory solution, and that may or may not involve an increase in price. It may involve an increase in time or relief from some other dilemma or other problem that the contractor is facing. So yes, it would be an interesting argument. So the way you've put it is interesting. One can say that surely the contract contemplated a change in price or an increase in price, but not necessarily. I can see arguments going there.
All right, thank you so much, Shaurav, for this. So next, I would like to know from Mr. Rohit that could the Ukraine war and its resulting price increases potentially lead to the prolongation costs as well in the construction industry?
My answer is yes. You see, the Ukraine war is not only causing an increase in the metal prices, it's also causing a disruption in the supply chain of a typical construction contract. Especially, there have been delays in the procurement cycles of many of the equipments and other accessories which are coming from Europe and probably from CIS countries and all. So definitely, I would say that there is a potential for projects even in India being affected by the Russia-Ukraine war, but it all depends specifically on the actual issues and which have taken place, any delay events which a contractor can establish that, yes, there is a disruption or a delay because of this. So there has to be a proper evidence and proper documentation to establish that. But theoretically speaking, yes, there is a potential that such a war can affect projects in India. And I have come across a couple of matters wherein we have given advice on oil and gas matters specifically, wherein the project has been delayed owing to Russia-Ukraine war, and the claim has been put forward by the contractor asking for prolongation cost and extension of time.
Okay. Thank you so much, sir, for this. So next question I have it to Mr. Ritin. But before asking that question, I just want to give two of my cases which I was working on where I was facing this particular issue. So the first case was in some country in Africa where the same clause was there. The only difference was instead of 60 days and 120 days, the timelines were 90 days and 180 days. So what had happened was the employer did recognize this particular force majeure for the aggregate period of closer to 180 days, but not actually 180 days. They gave approximately 160 days or something. So because of which the contractor could not invoke this particular clause. This was one situation. Then there was the second situation for one particular project in India, wherein the exact same clause was there. However, while granting extension of time, the employer wanted contractor to give it in writing that I'll give you extension of time on two conditions. One is you'll not raise any claim. Basically, you'll give the no claim certificate. And second, you'll not invoke this particular clause. If you satisfy these two conditions, then only I'll give you extension of time. Otherwise, I'll not give you extension of time. So these are the two cases that I have seen in my recent assignments. And on basis of that, I just want to know your views that what are the legal remedies are available to the contractor if the employer intentionally prevents the occurrence of these condition precedents which are there in the contract, and therefore the negotiation cannot take place. And what does the Indian contract and Indian current legal framework address such situations? So over to you, Ritin.
Yeah, now I think this clause is very interesting. I think Shaurav has articulated it well as a view calling it a renegotiation. Uh, I'll just echo some of what you and Saurav said, but I'll answer your question first.
Yes.
The fact of the force majeure period having extended for a particular period of time in a single set or over a span of time across multiple events, that determination is not something left to the unilateral determination of either the employer or the contractor. That has to be decided by an adjudicator. So in both your illustrations, Pallavi, I don't think the employer can get away by not recognizing that the force majeure period has extended for a particular period of time or making it conditional on anything. I mean, that's the position he can take, but that position gives rise to a legal dispute like any other legal dispute. I don't think, like I said, I don't think the employer can simply stand back and say, I don't think, in the example of this clause, that there's been a single force majeure event for more than 60 days. He can't say that, for example, about COVID, let's say, if the lockdown is gone on for more than 60 days or otherwise it fits the definition, that would be an arbitrable dispute. And someone else would determine that. But that's only the first part of this clause. So, well, let's have it that the arbitrator or both parties have agreed that the force majeure event has either continued for more than 60 days in a single period or in 120 days over some aggregate period. What do we do with this next half of the clause? You called it renegotiation. I think Saurav called it agreement to agree. I think that's exactly right. I can't see how an arbitral tribunal can renegotiate for the parties if there is no mutual agreement between the parties. It would really amount to rewriting the contract, I think. Indian law also doesn't really have evolved a good faith obligation to renegotiate. So I'm not even sure if parties took different positions while trying to attempt to reach a mutually satisfactory solution, how an arbitral tribunal or a court can find that satisfactory solution for them. The only last point I would leave you with is, a clause like we see those clauses on severability provisions, right? That if a particular provision of the contract is unenforceable, the parties will sit together to come up with as close a provision as possible to the original provision, right? So, for example, if we have a clause that is unenforceable or cannot be given effect to because of some foreign exchange rules, then parties can sit down and try and come up with an economically equal outcome. But I think here it will be far too difficult to pin the parties down to any position or for the arbitral tribunal to resolve that dispute. I suspect what we'll be left with at the end is that Section 56, which I started with, that this will then become a contract that is impossible to perform if parties are at such divergence and cannot reach a mutually satisfactory solution. So it's I think a lawyer's delight, this particular clause. But I think Saurav and Rohit and you and Kanika as well have spoken much more on the context of actually implementing a project. So certainly it would provide great impetus to the parties to find a solution. They would find some support in this contract. All the stakeholders would. But just speaking purely as a lawyer, it's a clause that I don't know how it will ever get worked through. On that pessimistic or skeptical note, I think I can stop here.
Thank you so much. I couldn't agree more with you on this, and I'm definitely going to use your advice while advising my client on these particular cases and similar cases that I'll see in near future.
Can I just add a little bit to what Ritin has said? And it goes back to the nature of the clause, which I found a little strange. And your second example is the employer says, I will not give you an EOT unless you give me a no-claim certificate. Now, that is the danger that these sort of clauses present, because that's actually a negotiation. And in a contract without a clause like this, and a contractor may be able to say, "Oh, I'm under duress," or "I've agreed to this under immense pressure, and therefore my consent is vitiated." In a contract with a clause like this, the employer will say this was a negotiation and you agreed with it, so you can't get out of it. So people have to be very careful about introducing provisions that on their face sound good, but actually in practice could come back and bite.
Thank you so much, Saurav. And actually, this was our last topic. So I thank everyone Mr. Rohit, Mr. Ritin, Mr. Shaurav, and Ms. Kanika for sharing your experiences. And actually, definitely it was very helpful to me, and definitely it would have been for the audience as well. I would also like to thank audience for this overwhelming response. And actually, because of this timelines, we won't be able to take more questions from the audience. But I'll just try to take one. So the question, which is partly answered by I think by Ms. Kanika on this, and by all the panelists actually, but still, if someone of you can quickly take this question, what should I do since price escalation clause was omitted in the contract? So if any one of you can quickly answer this question before we closing this session.
I think Ritin has already answered that, but
Yes,
I
yes,
think he's in a
yes.
better position to.
My suggestion will be, yeah, engage Masin, we'll prepare the claim, and then engage Shaurav, Ritin, and
That's the
Kanika to take
smartest,
it
yeah.
forward.
That's the best solution. Rohit's given it already.
No, Ritin, over to you. That was just in a joking fashion.
Yeah, no, I think, obviously this advice doesn't help at this point in time, but that's exactly why, drafting and negotiating these contracts is so critical. But yeah, if it doesn't contain a price escalation clause, it probably leaves you better off than if it contained one that actually limited you. And again, I think, Shaurav really was very articulate in those 4 points that he made, that find other provisions in the contract that will support your claim for increased prices, right? So I think you would have to find other contractual terms that allow you to make that claim. Again, it's not very helpful advice beyond a point, but arbitrators are necessarily bound only by the terms of the contract. So you'll have to find provisions in this contract, like a variation claim or a change of law claim, that will support your price escalation claim.
Yeah, thank you. Thank you so much, Ritin, once again for answering this particular question. Basically, this is the main question that the construction industry and the contractors representative who are preparing this claim are having. So, including me actually, because I'm also preparing these claims for my clients who are the contractors. So, thanks for answering these questions. So, again, I would like to thank everyone for attending this session, and hoping to have such more sessions again on different topics which are prevalent in the industry. So before calling it a day, I again thank everyone, including audience. Thank you so much.
Pallavi, thank you. It was
Thank you, Pallavi.
Thank you, Pallavi. Thank you.
Thank you. Bye-bye.